Supreme Court of India Sanju Rajan Nayar vs Jayaraj and another decided on April 23, 2024 SCC Online SC 582 Facts of the case. The marriage of the instant appellant was solemnized on July 21, 2006. During the subsistence of such marriage, his wife filed a complaint with the SHO police station Krishna Rajapuram police station alleging the appellant to have sexually harassed his minor child while visiting the child in the school, which resulted into registration of FIR number 555/2018 under the different provisions of the Protection of Children from Sexual Offences Act, 2012 and Penal Code, 1860. Respondent number 2, who was entrusted with the investigation of the said FIR, demanded and accepted monetary consideration from the instant appellant. Since the demands of bribe continued, the instant appellant brought the factum of such bribe to the notice of Karnataka Human Rights Commission. The preliminary inquiry FIR was registered with the Anti-Corruption Branch, City Bangalore Police Station on December 8, 2021 under the provisions of Prevention of Corruption Act, 1988. Based on the preliminary investigation, the authorities also accorded sanction for prosecuting Respondent number 1. Respondent number 1, Jayaraj, stands exonerated in the departmental proceedings with regard to the allegations of demand for bribe. As a consequence thereof, the FIR in crime number 63/2021 registered on the basis of the complaint made by the instant appellant, stands quashed by the High Court. Findings of the Court: the approach adopted by the courts in quashing the FIR in the attending facts and circumstances, is legally unsustainable. It ventured into an inquiry, unwarranted at this stage, holding that there is no direct evidence that the present respondent had demanded any money and that there was no material to proceed against him, completely forgetting, if not ignoring the material which had surfaced during the course of investigation, amongst others, the pen drive, allegedly, indicating his complicity in the crime. Under these circumstances, in the attending facts and circumstances, we allow the appeal, more so when, despite the accused having been exonerated in the departmental proceedings, yet the competent authority, vide Annexure P3, proceeded to accord sanction for prosecution. The High Court, in our considered view, failed to account for the principles enunciated by this court in the case of State of Haryana vs. Bhajan Lal, 1992 Sup. 1, SCC 335. We may also observe that it was the pleaded case of the Lokayukta before the High Court that the continuance of the trial was not on the very same evidence as what weighed with the authorities in exonerating the employee in the departmental proceedings. This fact also appears not to have been considered by the High Court in its correct perspective. The present appeal is allowed and the impugned judgment is quashed and set aside. Consequentially, the FIR subject matter of the present proceedings stands restored to be taken to its logical end, in accordance with law.